Welcome to another episode of the Sharkcast on litigation risks management, where we explore why businesses are so frequently sued and how to mitigate and navigate the dangers lurking in these risky waters. Join us now as we welcome our host, Kent Schmidt, litigation partner at the law firm of Dorsey and Whitney.
Welcome to another episode of Sharkcast. Today, I'm pleased to welcome back to the virtual Sharkcast studios my partner and friend, Mike Keys, who's back for another episode following his first episode a number of months ago. So, Mike, welcome back. Thank you for rejoining us here at Sharkcast.
Ken, great to see you. Thanks for having me back. Always a pleasure to be with you.
Well, Mike, today we're going to talk about AI and copyright. And before we dig into copyright law, just an observation, it seems like in almost every conversation with family members or colleagues or neighbors or whatever, somehow, some way, AI comes up because everyone's starting to discover the millions of applications of AI. And it's also the fact that AI is covered in conferences and events and CLEs continually. And we want to make sure we're adding new value-added material and not just mimicking the content of others. But do you find that in your circles that AI is just sort of a topic of conversation everywhere you turn?
I think that's exactly right, Ken. And at the risk of overstating it, I think it's probably the biggest copyright-related issue in our history, frankly.
It is, and it's just permeating our lives. You know, I chuckle when I think about this, but I decided a couple of weekends ago to try my hand at making homemade French baguettes with flour sourced from France, and I didn't use a cookbook. I use a combination of YouTube videos and AI to help me through the process and to sort of learn the process for the first time. They turned out okay.
I love it.
Not like right up to the standards, but
you're not going to quit your day job.
No, not quite yet. But if I'm now using AI to make French baguettes, then I think it can be used for virtually anything. And of course, no industry has been impacted by AI as much as what we would call the creative industries. Music and books and what comes under the heading of publishing, but perhaps even broader than that. AI is allowing everyone to be creative, everyone to be a publisher, of course. And therein lies the problem. So, Mike, you come from a background of IP litigation with particular emphasis and focus, at least in part, on copyright. So I'd like to chat with you about copyright infringement claims and how they're being impacted by AI. We have a number of topics we're going to unfold here, but can you just give us a general observation at the outset about this? And what I'd like to do is hear your reaction, and then we can give our listeners a little bit of a level set or refresher on some AI concepts, and then talk about a decision in particular relating to AI, and conclude with some thoughts on litigation risk avoidance, my favorite topic in the context of AI. So, what are your overall thoughts on AI and copyright infringement in particular?
Yeah, I mean, I think you really hit the nail on the head at the outset of today's episode. I mean, it's such a gargantuan issue in the world of copyright. As I mentioned, I think it's the biggest copyright-related issue that we've ever faced in the history of copyright. And copyright goes back to the founding of our country. Our first Copyright Act was enacted in 1790. It was very limited at the time, as you can imagine. It only protected, I think it was books and maps at the time, and charts maybe, or graphs. But since then, with technological revolutions, including the player piano in the early 1900s to radio broadcasts in the 20s and 30s, the Sony Betamax machine from the 1980s, the digital revolution, of course, of the 90s and 2000s, and now, of course,
Napster
we're
era.
hearing AI, Napster, exactly. Right. So we've seen over the course of our history a number of technologies that have come into play that didn't exist, and copyright had to adapt either through court decision or frankly, it was more court decisions trying to catch up with copyright, and then Congress stepping in to amend the Federal Copyright Act. So I think we're on the cusp of not on the cusp. We're in the kind of the bullseye of copyright evolution, 7.0 or whatever it would be at this point with AI.
Well, and you mentioned the concept of courts trying to catch up with technology. And of course, that relates to how swiftly technology is changing. And we've never seen that acceleration quite like we have in the last 2 to 3 years when AI has come into, I guess, common use. I mean, AI has been around much longer than the last 2 years, but
For sure.
it seemed like it just hit you know, homes and consumers within the last couple of years. And so it's moving, the technology is moving so fast, and courts are really having to catch up, right?
Yeah, that's exactly right. I mean, just like with other technological uh, evolutions, I mentioned the player pianos from the early 1900s, where the Supreme a case involving piano rolls for player pianos went all the way up to the U.S. Supreme Court, and the court said, "Well, this really isn't a copy." The perforated piano rolls that used to stick into player pianos. Court said it's not a copy. Well, of course, Congress stepped in and amended the Copyright Act to deal with the notion of what are called mechanical licenses, and we still have mechanical licenses that are part and parcel of the Copyright Act today.
So you've laid a little bit of the groundwork, but let's, talking about the origins of copyright law. But can you give us just an overview of U.S. copyright law in just a few minutes? I know that's a challenge, with particular emphasis on the fair use doctrine, which a lot of people invoke and use, sort of like the phrase hearsay or other legal concepts that people throw around, but actually has a very specific and defined meaning.
Sure. Well, I'll do my best here, Kent. So as I mentioned, our first Copyright Act is from the 1790s. Copyright is a concept that's actually enshrined in the Constitution in Article 1. It's one of those specific instances mentioned in the Constitution that Congress has the right to protect artists and inventors, or authors and inventors, and give them a limited monopoly over their works and inventions. And so that led to, respectively, the Copyright Act and the Patent Act. The Copyright Act has been amended over the course of many years, but it essentially protects, in its current formulation, what are defined as works of authorship. And you can think of that as being fairly broadly defined to include things such as books, movies, architectural works, paintings, works, creative works, if you will, as a shorthand. And so it gives certain exclusive rights to authors that allow them to prohibit the copying of those works, distribution of copies, and other related rights. So that's essentially the bundle of sticks that copyright authors enjoy. Now, you mentioned the concept of fair use. There's also built into the statute this whole notion of fair use in Section 107 of the Copyright Act that provides that it shall be an affirmative defense to a claim of copyright infringement, that someone has used someone else's work in a manner that the law considers fair. Kind of the quintessential fair use would be in the academic realm. It's not exclusively for academic related purposes, but a professor copies a portion of an article and distributes that copy of the article to his or her students to teach a concept. We think of that being kind of a quintessential type of fair use. But there's certainly other instances too. We've had a couple of recent fair use cases over the last it's been over the last few decades now, but most recently, a couple of years ago, the Supreme Court weighed in on the whole concept of fair use and copyright. So we have a bit of guidance from the courts, but ultimately, it's such a fact-specific issue. It's going to turn on the set of facts that are presented to the court in the context of the litigation between the parties that are at issue in the lawsuit.
And can you comment briefly on registration and how that impacts the rights of the author to assert a claim for copyright infringement?
Sure. So under the Copyright Act, there is a method by which you can register your copyright with the Library of Congress. It's a fairly straightforward process. You take a copy of your work, you submit it along with an application electronically to the Library of Congress, and they examine it. There's an examiner at the Copyright Office within the Library of Congress that will take a quick look to make sure that the prerequisites are met, and then you'll get your work registered. Now, you don't need to register your work in order for you to have protection. Under US law, you receive copyright protection once your work is what we call fixed in a tangible medium of expression. So once it's fixed and it's perceptible, you have copyright protection in that. Now, it's always best to register your work because you get certain enhanced remedies as a result of registration. And if it's a US work, you actually can't sue for copyright infringement until it's registered with the Library of Congress.
I see. Okay. Those are important foundations for our discussion that follows. But before we talk about AI, can you explain some of the ways in which copyright law has been adapting to what we might say a modern technology, including software code, including new digital applications and so forth, that I think lead up to the courts deciding cases involving AI?
Sure. So I guess I'd go back to the 1990s when the internet exploded and we had all sorts of issues with distribution and copying, making digital copies and reproductions of works. That's one of the instances where Congress stepped in and passed what's called the Digital Millennium Copyright Act. And so it's been with us now for a couple of decades. It works reasonably well. But we see copyright infringement related claims in all sorts of concepts, both in business and non-business settings alike.
One way I would understand it is that all the technology has done is made it easier to copy, and all types of things, all types of media. And with the ease with which people can copy and transform, which is something we're going to talk about in a minute, or transform at least to a certain extent, there are more copyright claims than ever because everyone has this ability to copy that you didn't have before, that was more tedious to do before. And so every time there's a technology that allows someone to copy, you have more and more, copyright claims. Let's talk about the transformative aspects of a copyright claim. Just putting it in very basic terms, how courts have dealt with this concept of the ability of a person to take something that has protection and then transform it until it no longer is a copy, but it is something that's new. What are the general principles that relate to that?
Yeah, so we could probably have a whole series of podcasts related to transformation when it comes to copyright. But essentially, I think it's best to think of this with the kind of dual principles associated with the Copyright Act. What we're trying to do is we're trying to incentivize authors and other creators to create works of authorship, to have a really robust output of creative content. Yet at the same time, we're also trying to balance that people will take another work and add to it and transform it and add to the betterment of society as a result. And so we have, on the one hand, we want to provide exclusive rights to authors so that they make sure that they're incentivized to create works. But at the same time, we don't want to squelch the creativity completely of other people. We want them to be able to, we all stand on the shoulders of giants, right? So we all want to incentivize future creators and authors to take what's in the existing corpus and be able to transform it and use it to create more works. So that's kind of the inherent tension that we have between copyright protection on the one hand and fair use on the other. And one of the elements that courts really look to try to balance those somewhat competitive interests is to look at, and this is one of the, and probably the most important fair use factor. It's the transformation that has been where the second comer has used the first creator's work and transformed it in a meaningful way to create a new purpose or to create a new work that still incorporates parts of the pre-existing.
That inherently sounds like a very, very difficult line to draw,
Right.
just by your description. And it's a great segue to talk about the case that we've uh, teed up here. It is Andrea Bartz et al. Versus Anthropic, the AI, one of the major AI platforms. Was issued by Judge Alsup in the Northern District of California in June of 2025. Why don't we talk about this case? It's an important case. I've enjoyed reading it. We've had some discussion back and forth offline. But for our listeners, can you summarize what the case is about? And then we'll get into how Judge Alsup applied some of these principles we've been talking about in the brave new world of AI.
You bet. So this is an actual class action lawsuit that has been filed by a number of authors. And as you mentioned, they sued Anthropic, which was actually founded by a number of former OpenAI employees that launched this new venture back. I think it was in 2021. And so they launched this new venture, Anthropic, which is a large language model that's branded under the name Claude. And so what they did here, allegedly, according to the lawsuit, is they did a couple of things. They trained the Claude using, I guess, two different types of books, although they're all works of authorship. They're all books for the most part. What they did initially is they obtained what Judge Alsup refers to as pirated copies of some of these books that were available on the dark web and other locations where you could actually go and download them. And so Anthropic initially started using pirated copies of books and a huge number of them to train Claude, but then ultimately started using actual copies that they obtained legally. And what they did, they obtained copies, Anthropic did, and its employees and other agents obtained physical copies of the books at issue, and then digitized them to create a massive library, and also used that to train the LLMs. So the authors were not happy about this, claimed that the process of taking the works, both the properly obtained physical copies and digitizing them, was an act of infringement. And then also using the pirated copies to train the LLM was also an act of infringement. So that's the basic claim at issue in the suit.
And the decision that we're going to discuss was on a motion for summary judgment, which
Right.
it was interesting to me, just as a litigator, that they sort of bypassed class certification and bypassed the motion to dismiss and just went straight to summary judgment. And front and center in the motion for summary judgment is whether this is a fair use. Of course, the distinction being drawn between the pirated copies and the copies that were legitimately obtained. So how did Judge Alsup come down on these issues for training the LLM with both pirated and legitimately obtained copies?
Yes, so we talked a moment ago about the whole notion of transformative uses. And conceptually, what Judge Alsop said was, look, for purposes of training the LLM, this really is a very transformative use of someone else's copyrighted work. I think he said it's exceedingly transformative, and quote, spectacularly so. So Judge Alsop really is on board with the whole notion of, at least in theory, using someone else's copyrighted work to train an LLM is very transformative in its own right. So in that regard, certainly that was welcome news to Anthropic and other AI developers that, look, we do have a pretty solidly in our camp ruling that using copyrighted works to train an LLM is in fact transformative and is a fair use.
And
So
let me interject a question there, just to make sure I'm clear, as from a very practical standpoint, what your understanding is as to what we're talking about for training. So, for example, I think my son's one of his favorite authors is Cormac McCarthy, who writes in a very, very unique style. And
yeah.
so, if you uploaded all of Cormac McCarthy's novels, however many they are, I think he passed away a year or so ago. You, you could then allow a user to say, I want you to write this in a Cormac McCarthy style, a subject completely different, and it would understand that style. Is that a correct understanding as far as you know from what is being referred to here as training the LLM?
I think that's right. And there's a very important limitation on what this case is about. This case is about inputs, not about outputs. So, what I mean by that is all Judge Alsop's ruling deals with is whether the concept of training an LLM with copyrighted content, whether that's a fair use. And we do have an answer on that rather narrow but very important issue. There's a whole other outstanding issue as to, well, what about the outputs? What what are those? Are they potentially infringing? It doesn't rule on that specific issue at all. It doesn't even touch it, and it says, look, this is just about. Judge Alsop says this is just about the whole notion of training. So we only have really an answer to a part of the equation here when it comes to a claim for copyright infringement.
So let's extend the Cormac McCarthy illustration
Sure.
To see if we can understand the inputs and outputs. That is the scenario I just described where let's assume that they're all legitimately obtained. Someone goes up, buys all the books, a copy of all the books, and they train an LLM to write in the style or to put out in the style of Cormac McCarthy. That would be a legitimate output, a legitimate input under the Judge Alsop's formulation. But a question he didn't decide is if that would allow the user to essentially say, give me the Cliff Notes version of the book, or give me a condensed version of the book. That's an output that he didn't reach, and that perhaps other courts have reached or will reach. Is that the distinction between input and output?
I think that's exactly correct. He didn't reach that other very important issue as to the outputs, the content that's created by the AI, and whether that would be infringing, and who would be the infringer in that instance. So that's not answered by Anthropic. There's another case. I mean, there's probably, I would say, 36 AI cases that are pending in various federal courts throughout the country. But one that was recently filed that I think will get to that issue is a case involving Disney, where it sued. And I think there's both the inputs and outputs issue involved there with respect to that AI. That was a case that was just filed. I think it's down in your neck of the woods, Kent, in Central District of California. And so we'll see. I suspect we may get an answer both on the inputs and outputs question there.
Okay. Well, I sense another episode of Sharkcast maybe a year or so from now.
There you go.
But in the meantime, let me just sort of put you on the spot, Mike, if you don't mind, and
Please.
ask you if you put the black robe on for a moment. And you're a district court judge. You're also a creative guy. We talked about in the last podcast about your music background. You have a lot of works that you've done and created, particularly in the music space. What are your thoughts on this? On how Judge Alsep decided at least this case, and to the extent you have thoughts on these issues that remain to be decided, do you think the courts are finding the right balance in that tension you talked about between encouraging new works and protecting the authors and originators of works?
Yeah, I must say I've kind of gone back and forth a little bit. But I have a lot of respect for Judge Alsop. He's been involved, as you know, in a ton of cases involving technology, and his opinions are always a good read. I think his analysis is correct. I think that in this particular circumstance, with the books that were legally obtained and using them for a very transformative purpose of training an LLM, I think that is the type of transformative use that the Copyright Act should encourage. Now, that being said, I think ultimately we're going to need some sort of uh, some congressional guidance here in terms of what exactly are the proper boundaries here. There is a bill that's pending. I'm not sure how far along it is. The Train Act. It was proposed by a group of senators about transparency in training LLMs. Yeah, I see some utility in that, but it only answers part of the equation again, or only provides specific information. And I'd say the Train Act itself, I think, presupposes that training an LLM would be an act of infringement, which is kind of contrary to what Judge Alsop just told us, at least in the limited context of that case. So I think we're gonna need to have some sort of congressional action here that really does uh, tell us what the proper balance is. And how that typically works in the copyright context is you get a whole bunch of stakeholders together. There's a whole series of hearings and meetings with Congress, and they try to hammer out what the statute should look like as a result of hearing from all these stakeholders.
Yeah, that seems to be a very, very important piece of the process, rather than Congress just starting to tackle these questions on its own without that input from the stakeholders.
Right.
Well, one of the things I want to cover also, because the whole purpose of this podcast and what I write and speak about is litigation avoidance. So whether it relates to AI or not, I'd like you to address from a very practical standpoint the steps that companies should take to minimize copyright infringement risk, litigation risk.
Mm.
And if you can, address some of the ways, perhaps outside the sort of stereotypical basic copyright infringement, where someone just photocopies an entire book or something of that nature, stands at the photocopier for hours and hours. That's kind of an obvious thing. But what are the ways that copyright claims sneak up and arise for a company that doesn't intend to violate the law or anyone's rights, and yet they find themselves embroiled in a major piece of copyright litigation?
Sure. Yeah, I mean, the number of or types of instances of copyright infringement are vast these days, particularly with AI. I mean, we've seen claims related to um, an employee taking, for example, a competitor's marketing collateral, feeding it into an LLM, and having a whole different type of work created, but it has a similar look and feel. It has similar graphical elements, and so on and so forth. Something like that is so easy to do from a an employment perspective as far as the employee
Mhm.
doing that. I mean, we see a lot of instances where you know the inputs are provided to the LLM, and you ask the LLM, "Hey, create this output that looks something like this." I think there's just numerous instances where that sort of thing is happening and can create potential exposure. So your point about litigation risks and mitigating those, I think, is so important in this context to make sure that companies should have AI policies related to what employees can and can't do with respect to AI. I mean, it's super valuable tool to have at your disposal for doing all sorts of things quickly and efficiently. But again, need to be careful to balance that against the rights of third parties and make sure that you're kind of staying on the on that side of the line that wouldn't lead to a claim of infringement.
Well, that sounds like a very, very tricky area to navigate,
Very.
constantly evolving. And the ability to, as I said earlier, the ability to copy means the ability to create a copyright infringement claim
Yeah.
so easily. And I appreciate what you said about policies. I guess I would add, every time I hear about company policies, I always want to add the addendum to training as well, because
So true.
policies without training are often, perhaps even worse than no policy at all. Because then you have people violating a policy, but not really understanding the policy or forgetting the policy.
That's absolutely true. I mean, it's critical that employees understand, at least at a high level, what the issues are here and what we're trying to avoid as a company in terms of running afoul of the law and running into potential copyright infringement claims. So you're exactly right. I mean, a policy without training and regular training and reminders, it isn't much of a policy at all.
Do you do some of that training in your practice of advising companies on not only the policy, but offering some guidance on the training or doing the training yourself?
We absolutely had, particularly in the context of creating advertising campaigns. So yes, it's something that we have been regularly involved in recently.
Very good. Well, I like all that litigation avoidance work.
I know you do, Ken.
The ounce of prevention is worth the pound of cure in this
Yeah,
area, as
no
in so
doubt.
many different areas. Well, that is about the extent of our time to talk about copyright infringement. And as a veteran of the Sharkcast podcast, we like to end with sort of a lighter note, talking about things outside the law, the world that exists out there. And when we were trying to schedule a time to record this episode, you mentioned in passing that you had a road trip, and it piqued my interest. And I don't really know much about it. I know a couple of facts, but can you tell our
Right.
listeners about your recent, sounds like epic road trip that you went on?
It was rather epic, I would say. So yes, when we tried to schedule this before, I said, I've had something come up. I'm going on a bit of an unexpected road trip with my son. We drove from Washington State with a U-Haul and his car behind the U-Haul. Drove all the way up to Anchorage, um, 2,515 miles to be exact. So we had an amazing time. I mean, that's a part of the world that I hadn't seen from that perspective. I'd flown to Anchorage many, many times, but have never witnessed it on the ground. And it was truly, truly sensational, a great father-son bonding experience.
How many days did it take you?
It took us 5, which was about 500 miles a day, which doesn't sound that grueling, but when you're on the Alaska Highway and it's 2 lanes, and you got to be constantly on the lookout for wildlife and so on and so forth, that it's a long 500 miles a day.
Yeah, I'm sure. A lot of really fantastic conversations with your son, I'm sure.
Amazing. Yeah, it was great. It was super memorable. Now that said, I probably won't ever do it again, but it was sure a blast.
Yeah. Did you stop in on the Dorsey Anchorage office while you were there, or did you have to
I
race
I
back
did.
to Seattle?
No, I stopped by and said hi to all of our friends up there and regaled them with some of my Alaska Highway stories, which people really got a kick out of.
Well, that's fantastic. Well, Anchorage, I have not been to Anchorage either by road or flight, and so it's definitely on my on my list of places to get to, whether for business or pleasure, or actually probably more likely a combination of both. So
There you go.
thanks for sharing that with us. Well, that's about all the time we have for this episode of Sharkcast. I'd like to thank you again for being here and a very interesting conversation. I'm sure we'll reconnect probably next year to talk about some of the emerging decisions in this area or other um, uh, IP related areas. So thank you for being here.
I would really enjoy that, Kent. So I'll look forward to next time. And thanks again for having me. Always a pleasure.
As always, I'm indebted to the extraordinary team at Dorsey for making this podcast and episode possible. For more resources on this and other litigation risks, go to litigationrisks.com, where more information can be found, including a book on managing litigation risk written by yours truly. Until next time, my friends, this is yet another reminder that there are a lot of sharks swimming out there in the murky waters, so swim safe.
This podcast is not legal advice and does not establish an attorney-client relationship or create any duty of Dorsey & Whitney, LLP, or those appearing in this podcast to anyone. Although we try to assure that the content of this podcast is accurate, comprehensive, and reflects current legal developments, we do not warrant or guarantee those things. The opinions expressed in this podcast are the opinions of those appearing in the podcast only, and not those of Dorsey & Whitney. This podcast is considered attorney advertising under the applicable rules of certain states.